way our agreement with the PRCS population was that we would only be appointed on the cases that made it to the probable cause stage. And our objectives really in designing this PRCS process was we wanted to make sure that if the clients wanted an attorney, they were able to get an attorney, and that they had the right to a timely, full revocation hearing if they wanted that. What we found, and the reason that we think that the resolution rate is so high, is because of the uniformity of the ER offers, the system that we compromised with and set up with the district attorney, where they have a standard offer. First offense is 90 days, second is 120, and the third is 150.
Third through the 100th violation. We're never going to offer the max.
The maximum they're looking at in these cases is 180 days with half time. So on the 90-day offer, it's 45 days actual time, 120 is 60 days, and the 150 is 75. We've had experience with these types of standard offers in the context of our probation violations historically in Sacramento County. For technical violations, we've always kind of as a starting point, it's been 30, 60, 90, 30 days on your first technical violation, 60 and 90. Those numbers came up at a time when it was a 1/3 good time work time was in place. So on the 30 days meant 20 actual days. So the numbers that we came up with in terms of a compromise were not really that far off from what we'd been using historically for our probation violations. And so I think that the consistency, the PRCS group coming out of prison, they knew what they were going to get. There's uniformity, there's consistency. They recognize that if they push it to a full revocation hearing, they may very well get the 180 days. They don't have to, obviously. The hearing officer, the judge, has a lot of latitude. But, we've had one revocation hearing so far, Chris, and what did the client get?
180 days.
So I think
we showed him.
They
15 more days, actual.
They understand that,
Good job.
and if they can save some time, they want to save some time. The other part of this is that we didn't want to, given the volume and trying to create an efficient system, get in a position where myself, Chris, or the attorneys that were involved were negotiating back and forth on the number of days. No, I want 15 days. No, I want 20.
No nickel and diming.
We decided.
Sorry.
And we historically have decided that in the context of our probation violations. It saves a lot of time, it's efficient, it's overall, it's fair to the clients, they know what to expect, and it's worked out well for us.